actually run that through, fully vet it, put it up the flagpole. I agree with Senator Haskell.
All right.
I just wanted to let folks know.
Thank you, Representative Russell. It's convenient that we have a member of the taxation committee here. All right, then, I'll imagine unless there's objection, we'll move out those two pieces, and it might be worthwhile if maybe that's something that should be more properly handled by the taxation committee. But we talked about part one of this. Did you want to go back to that?
What other bill did you do?
Representative Sanderson?
That was included in my bill. Talking with, Representative Hammond, did you have something to?
Thank you. I was going to ask for clarity on 4.
Yeah, 4. I think this was in the original version of 726. I think at least in our discussions as a caucus, we felt it was not necessary, and so we were going to just leave that piece behind. Point 5. Now currently reads. Now there's been discussion. There's been a lot of discussion about allowing a registered dispensary to qualify upon request of for-profit business. There was discussion about, there's some concerns about that, and one of the counter proposals was if we put in a piece that would require that 100% of the ownership has to be Maine, ownership of the dispensary needs to be Maine residents, so this isn't out-of-state folks coming in and purchasing our dispensaries. And that 100% of the board members are residents of the state of Maine, which is already the case with dispensaries. 100% of their board are already residents, but this would require ownership be 100% residents. Though there was some discussion in our caucus about whether or not restricting that further to say that only for the purposes of research and development. That's one proposal. Myself, I would go a lot further than that, but open discussion on that. And might like to hear from some of the folks who are from outside this committee who are more knowledgeable in this particular piece. But Senator Haskell.
Thanks once again, Senator Berkey. I think we're bringing up some things that need some time, need some vetting, need public input, and I also am sensitive to the fact that we are sending now several different bills up to the floor. Marijuana attached to them, and I would like very much to see them get all the attention they can. I think this is, these are kind of tail end pieces that don't seem to fit together in any kind of a policy way, and I don't know that I'm prepared to go forward with them now.
Okay, I understand, I appreciate that. I wonder if then,
Maybe others will continue.
you know, if that is the sense of the committee, I wonder if, I do think, especially this for-profit piece, I do think it's something I would like to discuss as a committee. I wonder if maybe in the second session we might, as a committee, ask for a joint order to report a bill here that we could consider it in the second session.
We carry the ball.
Or we could carry it over. Of course, that we wouldn't necessarily have, we've already done a public hearing on it, so we wouldn't trigger a public hearing.
You can have one.
Oh, I guess we could.
And that way, every bill, almost every bill.
Okay. Do we want to just carry it over then? Representative Sanderson.
I move we carry 726 over.
All right, is there a second?
I'll second.
Moved and seconded by Representative Sanderson and Representative Gattini to carry over 726. Any discussion on the motion? Seeing no discussion, then take a vote. All in favor of the motion to carry over? Opposed? Unanimous.
How many more marijuana bills
That's it.
Oh, really?
Michael's up, bye.
No, we have amendments to go, we have language review, right?
Yeah, Anna asked if I would at least do the language reviews that would be quick so that we can move papers up to the next phase. So I have just a small stack, if that's.
Great. Small.
Stack is not by definition.
That is it, yeah.
It's small now.
And so I,
Do 'em.
and yeah, so these are, so we'll start with 471, if that's all right.
Thank you.
And so this is LD 471, which is an act to improve childhood vaccination rates in Maine. And this was a straight ought to pass, and then there's a minority report ought not to pass. And when I was reviewing it, I realized that because it's in Title 20A, the education statute, that the term healthcare practitioner is not defined in that title. And that term is used in the language where it speaks about the parent seeking the exemption must include a statement of written documentation signed by a healthcare practitioner. And so I don't know if the committee wants to define that. I did attach to this sheet 3 different definitions that are already existing in statute of healthcare practitioner. And so 2 of them are from Title 22, one's from Title 24. Again, there's no requirement that you define the term, but I just wanted to bring it to the committee's attention that it wasn't defined if they wanted to. And then obviously the committee can come up with their own definition. It's not one that's already existing, but I just wanted to flag that and see how the committee felt about it.
Senator 15?
Thank you, Michael. With respect to these, the 2 different definitions that are from Title 22, do you know what part of Title, I mean, I guess you can look them up. Are they in the public health section? Are they in the main care services section?
I didn't bring it with me, but I can find out and right now. I can get
Yeah,
that.
thank you. What is Title 22?
It's insurance.
Insurance, thank you. Thank you. I appreciate it. You know, Michael, I think this is actually really important, so I'm going to want to maybe take some time to look at the statutes. I'm going to ask the people on the majority report to give me a little bit of indulgence to take a look at this.
Great. I just wanted to bring it to your attention.
I appreciate that. Great catch.
Absolutely.
Thank you very much.
Okay, so next we LD 736. And this is one that I didn't know if I even needed to bring it back before the committee, but I didn't want it to show up on the floor unexpectedly. But the direction was pretty straightforward. And this was an act to require the destruction of certain medical records and allow access to certain death records. And this was a unanimous ought to pass as amended. And if you remember, we wanted to strike Section 2 and send a letter to the Judiciary Committee to express to relay the lengthy conversation that we had surrounding that. And so this amendment would simply amend the title and then just include Section 1 in the bill. And I just wanted to make sure that that remained the committee's intent before it showed up on the floor.
That's right.
All right, great.
Who was on the majority?
It was unanimous.
It was unanimous. Perfect. Thank you.
Okay, next is LD 1076. And this was an act to enact the Vaccine Consumer Protection Program, presented by Representatives O'Connor. And this, I believe, at the time was also a unanimous ought to pass as amended motion. And I had the direction to strike everything in the original bill and replace it with a resolve directing the department to add a link to their website to federal resources surrounding vaccine injuries. And so just to briefly read through it, that it would read, resolve directing the HHS to increase public awareness about and access to federal resources related to vaccine injuries. In Section 1, Department of Health and Human Services directed to increase public awareness about and access to information related to vaccine injuries. Resolved that the department shall create a link on the department's official website to existing federal resources related to vaccine injuries, including but not limited to information about the National Vaccine Injury Compensation Program and the Vaccine Adverse Event Reporting System, or VAERS. And those were the two that were specifically identified as by the committee as wanting to be included. And so I don't know if that reflects if that looks good. The only question I had while drafting it was whether, because it wasn't clear at the time, the committee would want there to be a Section 2 which has a deadline by which the department shall make that happen, or if you just want to just leave it and as is.
I'm seeing no objection that we had asked.
Okay, so that looks good?
Yep.
All right, great.
I hope they will.
Yeah. If they don't, I imagine we'll hear about it.
Yeah, we will hear about it.
Okay, the next one is, which one you got?
I got 5.
Okay, perfect. LD5, and this is another straightforward one, but just wanted to close the loop here. And this was, so LD5 was an act to remove the limit on the number of patients a primary caregiver may provide for under the medical marijuana laws. And there was it was divided at the time. I think there was only 7 committee members present. It was 5-2, and the majority report was ought to pass as amended to amend the bill to increase the limit to 20 patients. And so, as you can see, 5 was stricken and 20 was put in its place, and then the title was amended to reflect that it won't be removing the limit, but just increasing it. So I just wanted to...
I have a question now. I was not here when this was voted on. Does this, so I know this was drafted in 2 separate bills in different ways. The 20 patients, that's not going to change the plant count at all.
That's correct. It will not change the time count.
Okay, that's just what I wanted to make sure.
All right.
I'll leave it about it.
All right,
So all set on that?
I think so.
Okay, great. Next, 470 would be good. This one is a little bit maybe a little bit more of a discussion on this one. And so again, I know that the committee has a lot of work to do. I appreciate you taking the time to do this right now. So if this is another one, I believe Ann is putting in a request to meet next Tuesday and Thursday to continue this process, but just some of the ones that were more straightforward, I wanted to move. And so this was, and again, this one is not necessarily as straightforward, so but it's ready to go, so I thought I would give it a shot. LD 470, an act to allow children's residential care facilities to ensure the safety of their residents. And what I have here before you is at the top of this first page is the language that was submitted by the sponsor, and then below it was just some minor structural changes that I had to that language. But before I go through either of those, I just wanted to bring it to the committee's attention. And if you turn the page to the back of this first page here, I included, and I attached to this packet is the official document, an excerpt from the official document. So if you'd like to look at it more thoroughly, it is there. But it appears that there is in rule right now a provision related to searches at the types of facilities that are being contemplated in this bill. And I am not, my concern was because just based on what appeared to be the committee's intent, that the rules currently allow more flexibility than the statute as written provides for, as far as the searches that would be authorized. And so what I attempted to do, and I can read through it and see if it works, is to mesh some of the language that's in the existing rule into the structure of the language that was submitted in order to make sure that it captures the intent of what I think the committee was trying to achieve. And I know that there was some concern that was raised about the use of illicit activity and what that meant. And in the rule, it talks about misappropriated articles and then items that may endanger the health and safety of the resident or of other people that are present. And so what I did was take some of the language from the rule and drop it into the framework of the constitutional test that was presented, and tried to mesh them together. And I don't know if this is something that the committee wants to read over and that we can take up again on Tuesday. I'm happy to talk about it now and read through it now. And again, the original form as submitted, it is on there, but I just, reading through it, was concerned that it maybe made things more challenging for the folks that the sponsor was trying to make things easier for. With the language that I, okay.
Thank you.
Great, thank you. And again, just because you're with the language that uses the rule, some of the terms from the rule is what is good. Okay. Okay, excellent. Well, thank you very much. All right, so we can move on to LD 433. This is another, I think, pretty quick one. And just as it's coming around, I'll just explain which one this is. This was LD 433, which is an act to clarify the liability of funeral practitioners. And the bill as submitted included a new provision at the end of a section dealing with funeral directors or practitioners of funeral services to make sure that they received the same immunity that was already existing in a different section, a different subsection underneath the custody of remains of deceased persons. And the direction that I received from the committee, and this was a unanimous ought to pass as amended, was that they just wanted to make sure that those folks were expressly covered. And so, and I read through it several times, and I think that in order to make sure that there's not any confusion with dueling immunity provisions, if you see on the bottom of this first page here, it just says a party, including but not limited to a funeral director or practitioner of funeral service. And that just makes it very clear that that applies to them. And I did include the statutory provisions in here if you'd like to look it over to see. But again, there was just a proposal to have a new immunity section in the funeral director or practitioner section, and it seemed to be better suited just to make sure that they were included in the existing provision.
That makes a lot of sense.
And then there was also just that was passed around as well. There is a fiscal note that's required, but there's no appropriations or allocations section. It's just a minor savings in the general fund and then a minor revenue decrease from the number of civil suits. And so there will be a fiscal note, but there's no appropriations or allocation section. So just wanted to make sure you saw that as well. And then there's just one final piece that I have to go over today, and then we can finish everything else up next Tuesday. And this is related to LD 423, and that was an act to require child-resistant packaging for liquid nicotine containers. And I'm not ready to present the full language because this was a unanimous ought to pass as amended report, and I was instructed to work with Dan Riley and Ed Miller to make sure that there was some agreement, and the amendment was to add a definition to the word tobacco substitute. And I've been working with Mr. Riley and Mr. Miller on this, and what I have before you, and again, I'll bring the full bill before you again, but they have not, the parties have not agreed on the definition. And so there's what you see here at the top of the page, and I apologize that I didn't include this on it, is that the top definition is the one that's being proposed by Mr. Miller, and then the one which includes under paragraph C, electronic nicotine delivery device, and then at the bottom of the page, this is the definition that is being suggested by Mr. Riley. And he uses the term tobacco substitute, and then pulled that definition for tobacco substitute from Vermont statute. And so, I don't know if it would make more sense for the committee. I know Mr. Riley is here. He would be better than myself at expressing what their disagreement is and why it's occurring.
Again, this is my opinion, we've been running around with this for a long time now. I think if we're going to have this conversation, I'd like to have make sure Representative Sanderson's here, Mr. Miller's here, and Mr. Riley are here, because I appreciate this spending. I think you're probably spending a lot of time on this, and I think the committee doesn't really need to spend more time on that if we don't have the people in the room that can help us get to a resolution. And if it makes sense for Mr. Riley, Mr. Miller, and myself, and Representative Sanderson to sort of be off
A little subcommittee.
a little group, a little conversation, and figure this out. We can do that without wasting the committee's time.
And I'm happy to participate in that as well.
I appreciate that.
Yeah.
I know you.
Okay. Well, thank you. I'll let you move on to
Representative Specky.
I'd like to hear the best joke from your toast tonight, and then tell you to get the hell out of here.
So the toast is going to be tomorrow, right?
Well, thank you very much. I really appreciate you taking me out of order here. And
Do you have a joke?
well, I'm still. I'll deliver it on Tuesday. Thanks a lot.
Drive
Thank you
carefully.
very much. Appreciate it.
Are those all amendments?
Oh, the ball, the yellow one.
Thanks a lot.
We can do an interview.
All right.
When we're all energized.
It is.
Thanks again.
Thank you.
It is. Oh, it's 5:38.
All right, have a good week.
We're going to be here for a while.
It doesn't matter. We can go for a while.
So we're,
That's good.
so, yeah, let's go,
What's going on?
I don't know what number it is.
I think whoever is.
1412.
It's Mr. Harper, Mr. Cummings, and that
Okay.
lovely woman that's been sitting there.
I know.
all afternoon.
I did say up front that I really appreciate all your patience all day. And I do very much appreciate your patience. I know people have waited a long time. Unfortunately, this is the last day of committee, and so a lot of these final things are kind of in one day. And so, all who have been waiting, thank you for your patience.
Not too much, I do.
You want one too?
We're up. Oh, we're up.
Okay.